if you have ideas, by the way, the policy works, as John said. But if you have ideas on how it should change for the better of ARIN and the community, then the people running around with the badges that say advisory council know they're really experts on how to write and submit policy proposals. You can also just do it yourself, but if you want someone to help you, find one of those wonderful people. Okay, we actually have, see, people did that in the past, and as a result, we have draft policies to consider. And the first one up is Draft Policy 2017-3, update to NRPM 3.6, annual Whois POC validation. As this is a draft policy, it's going to be presented by the AC, and I see Amy Potter coming up to do the presentation. Right click, right arrow.
Hi guys, my name is Amy Potter, and my colleague Alyssa Moore and I are the shepherds on Draft Policy 2017-3. This is one of the Whois accuracy policies that Leslie mentioned in her talk earlier, and a lot of the data that she provided there is going to be really useful for us in our discussions here, so thank you for that, Leslie. All right, I'd just like to make one note about the slides. Both the problem statement and the policy statement are redacted and summarized here, so I'd encourage all of you to take a look at your policy guides for the full text of both. The authors put in a lot of thought, and it's a really thoughtful text, so please take a look at that. There's also a really handy compare and contrast chart, because this policy is somewhat similar to another one that will be presented, I believe, directly after this, although it has a very different problem statement. So, from a public policy perspective, the failure to have an accurate ARIN public access to Whois information can present challenges to a number of different entities. It's the public safety officers and law enforcement agencies have trouble rapidly identifying the IP addresses that are used in ongoing abusive activities. It ends up wasting network operator time and resources spent on responding to potentially misdirected legal requests. And domain name and IP number resource hijacking, which Leslie discussed earlier, is another issue that pops up because of these inaccurate POC information. So the problem of potentially inaccurate information is most acute with legacy resources, as was discussed earlier. Legacy registrants are held by thousands of entities that do not have updated and verified points of contact. Many times the original POC was removed and replaced with a placeholder. Current ARIN practices do not allow for organizations that have been merged or acquired to update their POCs without entering into a registration services or legacy registration services agreement with ARIN. This causes many organizations to go through the process of updating, to not go through the process of updating their POC records. As the amount of criminal activity that goes on online continues to increase, users whose IP addresses have been abused need to be able to obtain redress. For organizations that have been tasked with protecting the general public, one of the most important registration records in the Whois is the last ISP in the chain of network providers there. To facilitate a timely and effective response to abusive and criminal activities, the ARIN public access Whois directory must be up to date and map the IP number resources to the correct network provider. Privacy, safety, security are all equally important outcomes and depend to a large extent on the accuracy of the ARIN public Whois directory. So, as I mentioned, this is we're starting with the current text of the current policy. States that during ARIN's annual Whois POC validation, an email will be sent to every POC in the Whois database. Each POC will have a maximum of 60 days to respond with an affirmative that their Whois contact information is correct and complete. Unresponsive POC email addresses shall be marked as such in the database. If ARIN staff deems a POC to be completely and permanently abandoned or otherwise illegitimate, the POC record shall be marked invalid. ARIN will maintain and make readily available to the community a list of number resources with no valid POCs. This data will be subject to the current bulk Whois policy. So I've sort of summarized the proposed changes to the text. You can find the full text in your handouts. So ARIN will perform an annual POC verification by sending out an email to each of your POCs, the admin, tech, NOC, and abuse POCs. For every organization that holds a direct assignment, direct allocation, reallocation, or a S number. It's important to note that similar to the next policy that's going to be presented, this does not apply to reassignments made to downstream customers or to end users. Legacy resource holders will also be able to update their POCs without entering into a contractual relationship with ARIN. So the sort of mechanism for enforcing this, each POC will have 60 days from the date that they were first sent the notification to respond. After the initial 60-day period, they will be non-responsive POCs will be marked as non-responsive. After an additional 90 days, so 150 days total from when the first notification was sent out, ARIN staff will conduct a thorough research and analysis before marking those non-validated, abandoned, or otherwise illegitimate POC records as invalid. Records that are marked as invalid will be taken out of reverse DNS, and their associated resources will be removed from the public who is thereby disabling reverse DNS. So we have some questions for discussion here.
Get to move over, but did you want to go over the question?
Ask them or do you?
You can ask them first.
All right. Is taking resources out of reverse DNS and removing them from the public who is an appropriate incentive to update POC records given the severity of the problems posed by Whois inaccuracy? If not, how can we effectively incentivize POC updates in a way that actually addresses these problems in a real way? And does the community support allowing legacy resource holders to update their POCs without entering into a contract with ARIN, even if there has been some M&A activity that has occurred?
Thank you, Amy. A few housekeeping points first. So back to that lovely flow chart. So this is a draft policy, as opposed to when we did this morning. We're much earlier in the process, and that's important for a few reasons, because what we're really looking for right now is discussion. A little less are you in support, but we'd love to understand that as well. But the AC is looking for feedback on how to reconcile. Is this a good idea to be pursuing? The other thing I just want to obviously point out is that you'll notice there's another Whois policy coming up, and there's been this lovely comparison chart pointed out. There's a tendency in these discussions when there's two policies that may be interacting to try and start making the two discussions into one. And my request to the community is please come forward to the mic, give as much detail on what you like and dislike about this policy, and leave the reconciling, drafting, merging to the AC. They will take all this feedback, they will meet, and they will decide how they're going to, reconcile the two policies in that way. So if at all possible, do that. With that, if you can hear the sound of my voice, either online or in the room, you are welcome to approach a mic, but we need discussion.
Peter Timish, Adrex. 2 points that we're trying to figure out for the discussion. First, we believe that organizations hold number resources, not POCs, so we're not sure how that squares with the first part. And the last part, we didn't see anywhere in the proposed text which would allow for the legacy resource holders of a merged or acquired entity to be able to update that. So if that could also be at least proffered, or if we can send something, we'd like to see that. Okay?
Thank you for the input. Rear microphone.
So, my name's Steve Ryan. I'm ARIN's outside counsel, and I just want to remark on the justification for the policy. It talks about law enforcement. Actually, civil society has an equal and equivalent need for the same accuracy. In other words, I think because of the origin of the policy, it could be lost that civil society that doesn't have agents and desk drawer subpoenas has the exact same need. So I can't address the POC issues, which I think this is a really important discussion though. But I really wanted to just emphasize that private parties need this. And we had a brush years ago with SOPA and PIPA, which were badly written bills in Congress that might have addressed issues in an overbearing way. And I think the discussion briefly this morning, there was a question from the front mic about legislation. We need to solve this problem to the extent that we can to show government that we can be the effective forum that we are.
Thank you. Front microphone.
Owen DeLong, Akamai ARIN Advisory Council. So a few things on this. Number one, I think there's a factual inaccuracy claiming that organizations cannot update their POC records without entering into a contract with ARIN. I think POC records can be updated. Org ID records, on the other hand, have difficulty being updated without going through the contractual process. So unless this policy addresses that shortcoming on org IDs rather than POCs, number one, the problem statement calling out POCs is inaccurate, and number two, the failure to provide a mechanism for org ID updates without a contractual relationship with ARIN is not going to solve the problem. I'm not sure whether that's a problem we want to solve. If John wants me to defer to him
Well, I think
and
Amy,
come back
Amy
to the
would
rest
like
of
to
mine.
speak first to that, and then John.
Oh, okay.
Okay.
So if you are a legacy address holder and you do not have any live POCs, you need to go through an org ID recovery. However, if you have gone through some sort of M&A activity between when you first received the address space and when you're trying to do that org ID recovery, you do need to go through an 8.2 transfer, which requires you to sign an RSA or an LRSA. So for certain organizations, they are not able to, certain legacy organizations are not currently able to update their POCs without entering into a
John?
contract.
Yeah, I agree what Amy just said. I'm responding to Owen. Owen, you presume that the requirement to enter into a contractual agreement means the problem statement's invalid, okay? The problem statement is about people who don't have updated POCs, and it's trying to solve those being updated. It's not clear whether or not for the people who have gone through mergers and have more substantial updates to do, it's not clear whether or not for some of them that is or is not an issue. You can't pre-presume it's an issue for all of them.
Another quick point, or?
I had other points, yes. But just to respond to John, I was saying that the statement that they can't update their POC records is inaccurate because they can. Notwithstanding Amy's little technicality, there may be some subset
Okay.
that can't. Okay. Anyway, moving on. I think we need to look at, we're trying to incentivize certain behavior here, which is updating your combination of org and POC information on a resource. There are two possible ways to incentivize something, and I will divide them into two categories of carrots and sticks. To the best of my knowledge, we're fresh out of carrots. I think ARIN has 3 sticks that are available to them in escalating order of collateral damage. The first stick, which has very little or no collateral damage, is the Section 12 review. The second stick, which has substantial but not devastating collateral damage in most cases, would be pulling the PTR records. I'm not sure pulling the Whois data in addition to the PTR records is such a great idea, but that's something we can debate later. And then, of course, the third stick would be actually pulling the resources themselves and reclaiming and possibly redistributing them. Perhaps we need to look at some level of process that escalates through those 3 steps, or perhaps not. I'll leave that up to the community to debate. I don't have a strong opinion one way or the other. I will say if we don't come up with some combination of carrots and sticks that works to some extent, Steve Ryan is right. We're going to end up having the legislatures of various countries that we serve decide that for us in various ways.
Thank you. I'm going to go to the rear microphone.
Okay, thank you. Aridoria Technicalities, which is a legacy holder for which I am the POC. I have, I guess, first a question which is just ignorance. When you say that you send a mailing out, do you send multiple mailings, or it's one, you miss it, and you're out of luck? So that's one question, because I know I constantly miss email that's sent to me.
So let's do the questions one at a time. That way, who wants that one?
We send a update per the policy once a year. It's an annual update. You get one every year.
So you get one. If you don't answer it, then you could go through a whole bunch of the repercussions before you got another. In fact, you might not get another. Let's say you didn't answer the first.
Completely distinguish our reminders for you to update from the process of what's happening to people who have out-of-date information. You could have updated your information last month, or 7 months ago, and we send you a reminder to update it again. So failure to respond or not responding is completely independent. The question is, what do you do with information where the POC hasn't been updated in some number of months or years, but that's independent of the reminder system, okay? You're tying it to an email, it's not tied to an email. The email is to remind you update your POC. Whether you do that or not, what they're talking about is a policy that would involve going through the entire database, whether they got emails or not, and acting on people who have not updated their contact for whatever reason.
So in other words, the punitive action is for not updating, not for not responding.
It's not for responding or not responding.
Okay.
It's literally for not, if you have a point of contact that has not been refreshed for any reason, a policy that goes through and takes points of contact that have not been validated in a certain time period would sweep them up whether an email was set up or not.
Okay. I think I'm more confused than I was before, but that's okay. That happens to me frequently. So I'll work on it for a while and see if I can understand it. In terms of incentives that was being talked about, I think if I understood one of the resolutions is to take the reference out of the who is. So if I was a bad guy, that would not be a bad thing for me to happen to me. Another thing that occurs to me is, and I've seen it several times here, now forgive me, I'm a newcomer, but I've seen several times here a presumption that law enforcement needs it, therefore we must do it. If we don't do it, they will make laws that we won't like. I wonder how come that's such a sort of given fact here. And I wonder whether you've had the extensive discussions over privacy and other things that take those questions and make them such a stated fact. And then the last thing I want to say in terms of the last bullet, if you were to make me sign a contract to update my POC, I'm almost positive I wouldn't. So I just would see that as a disincentive. Thanks.
Okay, thank you for your comments. I just have a quick question, or request, sorry. If you are going to speak, could you approach a mic? We have limited time, and I just want to get a handle on how many people we have to speak, because I see we have remote participation. So please line up if you would like to speak, just so we can give a good balance of time to everyone. We'll go to remote participation next.
Okay, we have Christopher Blecker from the Walt Disney Company. While this does put teeth into POC validation, this could also make the situation worse. Removal from reverse DNS could possibly break services for users, and removal from public whois may actually harm investigating owners of blocks. Having it marked as non-responsive or invalid is one thing, but having it removed from public whois removes one of the breadcrumbs in finding who is the actual owner of the block, especially in time-sensitive situations. Whois accurate is a good thing, but I'm not sure this is the right way to go about it.
Okay, I would ask all those at a microphone if they could try and keep their comments to 1 minute or less if possible. Far microphone over there, please.
Hello, Donnie Roisman with SoftLayer and IBM. I definitely agree that we should not ever be removing whois information due to non-compliance with POC validation. I also want to reiterate the fact that resources are assigned to orgs and not POC, so the way this is written I don't even think is actionable, where it states that if the POC is marked as invalid, then records will be taken out of reverse DNS. If anything, that would have to be modified to say if all POCs for a given org. I think there's another carrot actually, so Owen had mentioned that we ran out of carrots. Maybe there's a financial incentive. Maybe we charge a penalty fee if you're doing a renewal, annual renewal, where you have all invalid POCs. Or maybe we offer you a discount if all of your POCs have never gone invalid, et cetera, et cetera. So maybe there might be a little bit of a carrot there. I think also something that Leslie mentioned earlier today is perhaps doing a little bit of being a little bit smarter about renewing POCs. So if we've actually worked with an individual org at some point in time in person or on the phone, if we've successfully collected billing from them, clearly they're alive and responsive for those that are actually being billed. I think we can be smarter about kind of refreshing that trip odometer anytime ARIN actually interacts with somebody live and validates, oh, this information is accurate. So I think that also should be considered. I would actually be interested in having ARIN conduct a financial exercise to see what would it cost to actually perform a massive outreach by ARIN to all the invalid POCs. So any org that actually holds resources that has at least it has 0 valid POCs, I would say, how many man hours would that take? What would that actually cost for ARIN to proactively reach out a little bit more than just an email, maybe some physical mail, maybe some phone calls, etc., and try to reach out to those POCs. I think whatever we should do, we should remove any barriers to database accuracy. I don't necessarily agree in suddenly trying to impose penalties. Also, removing PTRs might actually prevent a POC from validating. It may actually break their ability to send email into ARIN. Keep that in mind. And many orgs, many legacy orgs, might not be actively using PTR, in fact. So I don't think we should consider that's an effective way to enforce this policy.
Thank you for your comment. Front microphone.
Jason Schiller, Google ASOAC. In response to your questions, if you want to break reverse DNS, I'm fine with that, but please, dear God, do not take it out of the Whois. I think taking it out of the Whois is actually just going to encourage hijacking. And the Whois, even if it's stale data, is better than no data. At least that gives me a lead of someone that I need to contact if there's an operational issue. I certainly would like the Whois to be more accurate. I do support legacy resource holders updating their POC information, certainly if they can prove that they are the authentic holder of that space, which is what we have a consultation about currently. Yeah, I just want to echo the response, please, dear God, do not take it out of Whois.
Thank you for the comment. Rear microphone.
Hi, Elvis Velavi for Escrow. I agree totally with Jason. Don't remove it from Whois. It's gonna create a bigger mess than it already is. As for allowing legacy resource holders to update their POC, please do. Please allow, of course, with due diligence done, allow any legacy resource holder to actually get their contact data correct. Basically, Whois and the registry are probably one of the most important things ARIN should care of.
Thank you. Thank you for your comment. Front microphone.
Hey, Chris Woodfield, Salesforce, ARIN AC. A number of people before me have brought up many of the points that I originally came up here to make, but I have one left, which is that there was a question about the email validation and what outreach would be involved in something like this, and I would expect that, given the severity of the stick here, that there would need a dire need for additional outreach if we were to adopt a policy, and I believe that additional outreach required should be codified in the policy. Like, what do we do to try to reach somebody who hasn't updated their POC record? If we're going to do this, that should be stated in the policy as well, is what chances people have, what opportunities do people have to correct this before their resources are pulled.
Thank you for the feedback. Rear microphone.
Kevin Bloomberg, The Wire. Don't remove the Whois, mark it inaccurate. Have no problem with the removal of PTR, but my question actually is, can we remove the PTR on a legacy record that we do not have any contract with? Does that put ARIN at major risk, changing something that has been the way for 20 years? Which actually comes to, you don't need to answer it, John, because I'll tell you why. Because it really comes down to the bigger problem. There's a lot of things in here that I think we need staff and legal on now rather than later, such as contractual relationship is hand-tying ARIN in terms of what it can and can't do, rather than saying RSA, LRSA. There's no contract can be done. And I'm just wondering if it's better to have all of this dealt with staff and legal early on now, so we know what the pitfalls are, so that we can fix it, rather than having it dumped on us as it's about to go recommended. So if you'd like to, I'd love to hear the answer, but there was more to it than just that one.
To answer the question, the contents of the registry and the services that we provide are what the community wants us to do as the Board of Trustees deems from your input, okay? And while staff and legal will do a review and say if there's a risk, ultimately, we need to see an exact proposal in order to know the exact risk, okay? If you said, is there any risk if we set a policy that doesn't provide reverse DNS services for some people in the registry? And I say, no, as long as it's clear who. and you say, okay, we'll randomly choose 5% of the registry and take away its DNS service, I'd say, wait, now there's a risk. Okay, so the exact proposal matters for the risk assessment you're asking for. Okay, we're happy to do one early on this, but please give us text. Don't ask us to do a risk assessment on anything that might have come up at the mic in the last hour.
Thank you. So I have concerns, as stated, with the word contractual relationship and it tying ARIN. I have concerns with can you remove legacy resources, but I believe this policy is a good policy overall. It just needs some polishing, and that's my feeling on it.
Okay, thank you. Remote participation?
Christopher Becker, Walt Disney Company. +1 to Donnie's comments around financial incentive. Discount for all validated POCs would be a great carrot to try. And polling customers for POC validation at or around billing time sounds like a great idea for staff to take on.
Thank you for that. Front microphone.
Thank you. Chris Tassett, Tassett Law, ARIN AC. Without commenting on the specific remedies that this policy suggests, I just wanted to back up and talk a little bit about the context of this issue, and specifically to respond to comments made around concerns about law enforcement and privacy. It seems to me that law enforcement is part of this community. It's not us against them. They've come here, they're participating in our process, and we owe them the same courtesy as we would any other members of our community. The second thing is the privacy balance has already been struck by the policy. What we're talking about is the accuracy. Nobody is using that information to get any more information without court supervision. If information that flows from that POC record needs to be obtained either by law enforcement for their purposes, perhaps to save a life, not just to charge someone, or for a civil suit, it would be done pursuant to a court order. So there's no privacy breach inherent in fixing a problem. And my last point is that with the run out of IPv4, we're past the point where needs-based policies can serve as a bit of a discipline for improving the accuracy of the registry. So we really need to be focused on that part of our mandate and shore it up as much as we can going forward. Thank you.
Thank you. Side microphone.
Craig Thompson with Caldwell Global Communications. A few years ago, we had a nonprofit customer that we had served for many years, and they said, hey, we have some IP space, could you use it? And we said, well, sure. At the time, it was pretty difficult to try to work through the process of acquiring that IP space directly. We talked to our upstream and said, we'd like to route this. They said, can you get us a letter that shows that you have permission to? We said yes, and so we routed it for years and years and years, and finally last year worked through the process of actually getting the space transferred. It took a lot of work because there was chain of custody issues that had to be resolved. And that just brings me to the point that in a lot of these cases, if the legacy space is being routed, it seems like the ISPs and the carriers that are routing this space need to be contacted to find out, well, who is this customer? Who are you routing it to? Because if someone had done a lookup on this particular IP space we were using for years, it would have shown someplace out in the west part of the U.S., whereas it was actually being routed to us in the east part of the U.S. So my question for the ARIN staff is, in beginning to look at these unallocated or these allocated space that you don't have contacts for, do you already have a plan in place, or do you have contacts with the carriers to try to get some of the low-hanging fruit of finding out who it's actually going to? Do you have anything in place for that?
As it turns out, the number resource policy manual is really clear when it comes to POC validation. And what it actually says is that we send an email out every year. It actually doesn't call for us to do research, investigation. It doesn't call for us to contact upstream ISPs. It doesn't call for us to do a lot of things. We're happy to do more. Mind you, the moment you tweak that knob, be very careful, because the denominator has hundreds of thousands of records. So anything you add is material. Okay? But if you want us to do something more as part of POC validation, either before we send the mail or after we send the mail or for the non-responsive ones, that's certainly in the realm of the community to specify, and we're happy to do it. But we're not, if you're asking organically, have we branched off in that area and are doing creative things? No, we're not.
Not currently, okay.
Right.
And I would like to say that I am for the allowing organizations to update the information without having to enter into a contractual relationship. I think that's a great idea. And I'm also for the idea of doing financial incentives for companies that do wish to update their data, which hasn't been updated.
Thank you. As a small housekeeping, I've not seen anyone approach a mic in several minutes, so I'm giving you last call that I'm going to close the mics after the next speaker. So if you'd like to speak, please start making a motion towards a microphone or start typing in jabber. Rear microphone.
Hi, Jason Bodie, Rice University. I don't support this, the breaking of PDR records or removing contact information, and I'd like to see a conscionable effort made by ARIN to perhaps pursue the organization through registered mail or something, or a registered agent of that organization in order to obtain the information that it requires. We've extended address space to other organizations, to better the community as a legacy address holder, and we sometimes find that they could be otherwise caught in the crosshairs of this, breaking of that information and not being able to get, the proper communication. But perhaps, contacting the registered agent or the organization would be helpful for the community. Thank you.
No, and I just echo, I think, what John said. We're happy to look at these kind of things. Just realize that there is a large number of contacts, and it could start to not scale well from a cost, especially if we have human interaction. So it can obviously impact cost, which we're always very sensitive about. The microphones are closed unless you're making a motion right now, and I don't see it. And if there's no one typing, we will do the last two comments from the front, unless a remote pops in. So go ahead.
Hi, it's Bobby Flame from the FBI. In support of this policy proposal, like was mentioned in the presentation, Whois obviously is important to law enforcement. But one of the other things is it's also important to a lot of other public safety agencies as well. Consumer groups, it helps us with identifying victims. It helps the CERTs. It helps anti-abuse groups. So it isn't just law enforcement. And also this policy goes towards just being able to serve legal process, which was mentioned before by Christian. So this is very, very important that people recognize this. And in part of Leslie's presentation earlier, she said there were 3 steps, the contract with the RSA, whether we do a policy or legislation. And John, you had talked about, you hadn't heard anything about legislation, but in private, we really are talking about it. And we are here to try to work this out. I've been coming to ARIN for 10 years, and if I have to hear Whois come out of my mouth one more time, I'm just gonna, I don't know what. But, it really is important, and we really are trying to be a good community member. But this is so important, not just for the attribution and finding the bad guys, but IP spoofing, the health of the internet in general. So we're agnostic, obviously, about the technologies and the sticks and the carrots, but we really do want to make sure that we see it work. So thank you again.
Thank you for your participation. Just for those not aware, Bobby and also Jason, 2 meetings ago, or last meeting, did come and give a good presentation that you can go see in the archive that explained a little bit from their perspective some of the challenges they're facing. So, any remote participation? Nope. All right. Last comment from.
Hi, Alain Durand. I was wondering if it would be worth somehow separating the validation for POC that like resources are really old, like legacy of predating ARIN, from the resources that have been managed by ARIN from the get-go, because it seems to me that for the legacy stuff, it might be a self-corrected problems. As we talked earlier this morning, transfer actually increase the accuracy of these things, and the more of these resources get transferred, the less this problem will be relevant. So it's just a thought that came to me that we should maybe want to separate this into 2 buckets.
John, quickly? Or did you want?
People have noted that there's actually 3 buckets. There's legacy, there's ARIN issued, and then there's IPv6. And you could actually end up with separate requirements for all of them, recognizing that as we go forward, eventually the requirements for IPv6 may actually be the most important ones long term.
Well, actually, if I can comment on that one, we may even have a worse problem with IPv6 because there's even less carrots because folks come here and get a large allocation and never come back.
Very true. Any last words, Amy? No?
No.
Okay. Thank Amy for her presentation. This is a draft policy, so the advisory chair gives me his indication. He's indicated we do not need polling at this time, so that ends this discussion. Thank you very much for your input, and I'll hand over to John for the next policy.
Thank you. Wonderful discussion. I'm sure that the happy folks in the AC will ponder all this. Again, they're in the crowd, so if you see an advisory council member, feel free to reach out to them, talk to them about anything you didn't get a chance to come to the mic with. They have the colorful job of digesting this and trying to see if there's any way to incrementally make it a little better so the next time it comes here, it gets a little more support. Or deciding it's pointless and one way or the other, it's their job to try to advance the ball.